Hello everyone and welcome to the second video for chapter 10. In this particular video, we're going to keep talking about forensic assessment for criminal trials and criminal settings, but in this case what we're going to talk about is assessing for not guilty by reason of insanity, which you'll hear me refer to throughout this mini lecture as NGRI. Okay? So, as we just talked about in the competence lecture, this is a separate issue from competence and should be treated as such. So a not guilty by reason of insanity, or NGRI plea, admits you committed the crime. You're saying, I did this, but I shouldn't be held responsible for my actions because at the time of the events, I met criteria for insanity for whatever jurisdiction I'm in. So I am not responsible, but I did it. So for that reason, this can be something that you want to seriously consider whether you do this or not, because you're admitting guilt. You're admitting you did this by saying you're going to use the NGRI. The defendant is the one who has to raise NGRI, and you raise it early on in the trial, often at the time of arraignment. And you can enter multiple pleas. You can enter not guilty and NGRI. Again, this is really tricky because NGRI is technically an admission of the crime. So even if NGRI is dropped later, evidence of crime commission may have already been presented. So you kind of get yourself in a pickle. Okay? This becomes a little bit tricky because the assessment is going to be at the moment of the act, at the moment they committed the crime. And this is really difficult for psychologists to do in general, but even more difficult to assess if the client says they didn't do the crime, right? So no one will be found NGRI if they don't admit to the crime. So how many people plead NGRI? The community believes that about a third to a half of people charged will file a not guilty by reason of insanity plea. And most community people see it as, to be perfectly honest, crap or a cop-out. In actuality, only about 1% of all criminals even attempt an NGRI plea. And the success rate of an NGRI plea is only 25%. So we're talking about 0.25% of people successfully use NGRI. So that's really important to know. And in fact, this may be a little bit of an underestimate of the proportion of cases in which significant psychological impairment is accepted as part of the criminal act, for some of the reasons we'll get to later in this lecture. Plea bargaining is another thing that can come into play here. With a plea bargain, it would never go to trial. They would enter NGRI, then they'd get their psych evaluation, referral for evaluation of criminal responsibility. Then there'd be some resolution without a trial taking into account the agreement that this person met criteria for insanity at the time of the act. Or you can plead guilty to a lesser charge with treatment instead of going to jail or prison. So a lot of really interesting history here in terms of how insanity is defined. And one thing I really have to note here is that the terms insanity or insane are not clinical psychological terms. These are not diagnostic terms. This is not something like you would come to my office as a clinical psychologist and I'd be like, well, you are insane, so we're going to treat you for insanity. No, you'd give them a diagnosis like depression and eating disorder, schizophrenia, what have you. So this is a legal term rather than a psychological one. Original one, which I love the name of, is the wild beast test. So you're not responsible if you have no more control over your own behavior than that of a wild beast. I know. More commonly used one is the Monotone test. And this is from the case of a man who suffered delusions and killed the secretary of the British Prime Minister while they were attempting to kill the Prime Minister. Okay? So the Monotone test is a standard of knowing right from wrong. This states that if people are insane at the time they committed crime, it is because they have a mental disorder So they didn't know the nature of the act, or they didn't know right from wrong. This test is used in all cases tried in federal court in the US, and in about half the cases tried in state courts, so 28 states. The Bronner rule stemmed from that model penal code we've talked about before. This rule states that a defendant is not responsible for criminal conduct if he, and again I'll give you a quote here, at the time of such conduct, as a result of a mental disorder or defect, lacks substantial capacity either to appreciate the criminality, wrongfulness, of his conduct, or to confirm his conduct in the requirements of the law. This Bronner rule is used in 14 states. There is the irresistible impulse test. This is the inability to control your actions. You're insane if you commit a crime in an uncontrollable fit of passion. The Durham test is from Durham v. US in 1954. This is back to our good old friend Judge Bazelon, we've talked about several times, who was a mental health-oriented judge. And he is the guy who said that psychologists were qualified to testify. And this case said that to establish NGRI, you had to show that the person had a mental disease or defect, and to show the criminal act is a product of that. This was later refined in McDonald v. US. You needed to prove substantially impaired because of the disease or defect. You're not just excused because you have some sort of mental disorder. This was actually overturned in 1972 in US v. Browner, and that reverted back to the Monotone test. So again, the Monotone test really is sort of the standard that's often used. There's also the American Law Institute tests, which says people are not criminally responsible if at the time of a crime they had a mental disorder or defect that prevented them from knowing right from wrong, or from being able to control themselves and follow the law. This was sort of a response to a call for tougher standards after the next case we're going to talk about, which is US v. Hinckley, which is 1982. And John Hinckley Jr. was a man who attempted to assassinate then-President Reagan in order to impress actress Jodie Foster, whom he was stalking. So he believed that if he killed Reagan, somehow he and Jodie Foster would be together forever. He was found NGRI, and he was civilly committed. He was committed to a civil facility. And until very recently, within the past 5 years or so, he was still civilly committed. So from 1982 until I believe either 2015, 2016, something along those lines. People didn't realize what civil commitment meant. They thought he was just sort of like going to the lap of luxury. And so they had a call for tougher standards after that, because Reagan was a beloved president. People were outraged that this guy quote-unquote got away with it. But as you can see, he was in prison for over 30 years, right? Which, depending on your municipality, might be a life sentence. So he was released. He does live in Williamsburg, Virginia. His mother is there. And he actually, at least at one point, was working as a handyman for a Unitarian Universalist church. So really interesting ideas there that we don't have time to get into. Then there is the National Defense Reform Act in 1984. And this said that you had to have a severe mental disease, the crime has to be a result of this, and the nature of, and you had to sort of not understand the nature and the quality of wrongness. And this was, again, back to the Monotone standard, essentially. But the important thing about this National Defense Reform Act is that the burden of proof for NGRI is now on the defendant. It also established the equality of psychologists and psychiatrists as expert witnesses in these type of trials. Beforehand, psychiatrists with a medical degree were sort of looked on more favorably. There's also an American Psychiatric Association recommendation that you should find people NGRI only if they do not know right from wrong at the time of the crime. An inability to control themselves and follow the law is no longer sufficient. And again, this is really in line with that Monotone standard. So what are the characteristics of those who are found NGRI? Considering that confusion is a major feature in the inability to tell right from wrong, it's probably not surprising that 2/3 of the people have schizophrenia, because confusion is a major feature of schizophrenia as well. About 50% are Caucasian, 86% are male, and their average age is 32. Now, what as a psychologist do you do to assess whether someone is NGRI? This is a lot different than some other assessments we do because this is psychological detective work. We're not dealing with what someone's state like right now. We're dealing with what was their state like at the time of the crime, which could have been months, but often was years ago. So we have to really do some detective work and some digging to figure out what's going on or what went on, honestly, with that person. So records become really important. School records, criminal history, police reports are especially important because they provide an account of behavior close to the time of the crime. Any previous psychiatric treatment, those records. You want to do an interview with the defendant, but also you want to interview their family members, the victim if they are still alive, witnesses, employees, neighbors, you name it, whoever you can get who can try to put together a picture of what that person was like at the time of the crime. Especially those with whom they may have interacted with on the day of that crime. Very important. Then there's traditional assessments, psychiatric or psychological tests. The problem is these only give you current information. So the WAIS is recommended that we talked about before, the Wechsler Adult Intelligence Scale. The test retest for this instrument is 0.95. That's your temporal stability, the ability of your score to stay stable over time. So this is very stable. So it gives you a fairly good indicator of what their IQ was like at the time of the crime, unless they've had something horrible happen, like a traumatic brain injury. The MMPI-2 is also recommended. It will identify people who are malingering, but not the mental state at the time of the offense. If they're not malingering, but do have some sort of psychological disturbance, that can be really helpful. So for example, if they're showing signs of something like paranoid schizophrenia, that again is something that you often have fairly stable over time. There are NGRI specific instruments. One of the ones that's used quite a lot is the Rogers Criminal Responsibility Assessment Scales, or RCRAS. The clinician provides the data based on everything they've collected. There are 25 scales, each is one item where you rate aspects of behavior, and then you condense those 25 scales to subscales. Malingering, organic mental related, so is it a brain problem, major disorder, cognitive control, which is do they know right from wrong, and behavioral control. These are useful for organizing data and serves as a guideline for data collection. My forensic psychology professor from graduate school, Jack Graham, referred to the RCRAS as pseudoscience. He said, you're just making ratings and it's a decision tree. There's not really a lot of science behind it. One of the problems with this, why he didn't like it, is that inter-rater reliability. So if I rated this and then one of you rated this, is all over the board. So it can go anywhere from a correlation of 0.45, which is less than chance, up to a correlation of 1, perfect. Ideally in psych, we want it at a bare minimum of 0.7. For things we're using for decisions like this, we want it really high. Because again, we're going to write a report that's going to be critiqued, right? It does give you 3 outcomes, sane, insane, or no opinion, which as you can imagine would be super helpful. Now, that report that I just mentioned, how do you write that? This is going to be pretty similar to that incompetency report we talked about last mini lecture. So you've got your referral source, the defense attorney, the court, the prosecutor's office, whoever told you, hey, you need to evaluate this person. Informed consent and confidentiality. So you have to say that you've discussed this with the defendant and their attorney, especially who's going to see this information. Again, this is going to the judge, And knowing this information, the defendant agreed to participate. Sources of information. Who did you interview? What records did you look at? What tests did you give? You want to list them all. You want to have history, social, medical, mental health, substance abuse, legal. You want to say their mental status at the time of evaluation, how they've behaved in jail, the defendant's account of the alleged crime before, during, and after, interpretation of data, including malingering, and opinions about mental status at the time of offense. And again, usually this is not on the ultimate issue of whether or not they are NGRI. That is going to be decided by the trier of fact. This is where you've got to sort of hint at your opinion on it. This is the most important part. You have to sort of say this act was related to their mental status. They understood what they were doing, they knew it was wrong, or they did not. So a couple cases, examples of famous NGRI defendants. David, son of Sam Berkowitz, was a serial killer in New York City. He said that a barking dog sent him messages to kill, and he was found guilty, even though 2 different psychiatrists diagnosed him as psychotic, but turned out they made the right decision because he later said he made up those delusions. Andrea Gates is a much sadder case. If you're not familiar with her case, she drowned her children, and she actually had severe postpartum depression with a lot of almost unusual features with it. At her first trial, she was found to have a mental disorder but still be guilty. And then at her retrial, she was found NGRI, and that was in 2006. Now, again, that doesn't mean she's scot-free. In fact, she's in a maximum security state mental institution. Defendants who are found NGRI typically have a record of prior arrests or convictions, although this rate does not exceed that of other felons. They come from lower socioeconomic status. They have a prior history of psychiatric hospitalizations, and they've previously been found incompetent to stand trial in a lot of cases. There are some problems, as you could imagine, with using the insanity defense. There's a fundamental difference between the law and science of human behavior. The law assumes individuals have free will and are generally responsible for their actions. However, clinical research supports the notion that psychological and physical forces affect human behavior, and people may not be able to control their behavior as much as the law portrays, even when they have their full mental faculties. The uncertainty of scientific knowledge, especially as it relates to abnormal behavior, is important here. During a typical insanity defense trial, the testimony of the defense clinicians differs from the testimony of clinicians handled or hired by the prosecutors. So the jury has to weigh the claims of these 2 experts who disagree with their assessment. Some people see this as lack of agreement as evidence that the clinical knowledge in some areas may be too incomplete to be allowed to influence these important legal decisions. One of the most heard criticism is that it allows criminals to escape punishment, but as we've seen, you're still going to be locked up, right? There's also the problem of time that I keep coming back to. So psychologists and psychiatrists are asked to determine if people were insane at the time of the crime, which may have been months or even years earlier. That's really difficult to determine, and very few instruments actually measure that well. There are some other options for verdicts now besides NGRI. There is guilty but mentally ill. This is a verdict that states that defendants are guilty of committing a crime, but also suffering from a mental illness that should be treated during their imprisonment. This is not a substitution for NGRI. It's very controversial. So they're suffering from a mental disorder, but still responsible. Guilty with diminished capacity. Here, a defendant's mental dysfunctioning is viewed as an extenuating circumstance that the court should take into consideration in determining which crime that person is guilty of. For example, a defense attorney could argue that their client, as a result of mental dysfunction, could not have intended to commit the crime. So the person might be found guilty of a lesser crime, so manslaughter versus first-degree murder, which again often comes with a lesser sentence. Mentally disordered sex offenders, they are convicted of a criminal offense, but considered responsible for their actions. They're committed to mental health facilities like NGRI, so civil commitment. This reflects the belief that sex offenders are psychologically disturbed, and it also protects sex offenders from the abuse they receive from other inmates in prison, especially if they are pedophiles. States have been getting rid of this because it's difficult to imply, and they're less concerned about the rights and needs of sex offenders, mostly due to public outrage. All right, that's the end of this mini lecture. The next mini lecture will address some other topics within this chapter.